Sam George, thank you very much. Now let's try and get some footages of their demonstration, and you will see what Sam George led in the course of the week, blaming the Chief Justice, and their comments are direct at the Chief Justice that, you know, there has been a delay, and which they suspect is deliberate, in not getting the case over with so that the president will sign assent to the anti-gay bill, anti-gay, let's call it, bill, to become law. It's been 220, almost 230 days. But is it really the case that the Chief Justice is to blame or the Supreme Court is to blame? Sam George.
Yes. Good morning, Samson, and good morning to your viewers and listeners. The fact is simple. We are simply using the standard of the Supreme Court and demanding that the precedent that has been established by the Supreme Court should be applied in the family values case. We have seen a press conference addressed by a gentleman from the Supreme Court making all kinds of false allegations and suggesting that the case is not right before the court. That is a palpable falsehood. The injunction case, which is the reason why Parliament is unable to transmit the bill to the president, has been fully executed before the court. All filings and pleadings have been completed. In fact, the Chief Justice, who was presiding judge of the panel, had given 17th of July for her judgment. He chose not to give judgment on that day. So any suggestion by anybody, be it from the Judicial Service or a judge of the Supreme Court, that the case is not ripe for judgment is an untruth and it's factually incorrect. So let's state that for the fact. Now, if you look at the precedent that has been set by the Supreme Court, and I'll give you two cases this year, just this year, two cases. In one of the cases, Nick Mako Samuado was lawyer for Roxanne Nelson Dafiamepo in the injunction petition against the approval of ministers in Parliament. Nick Mako Samuado filed his documents in the morning before the Supreme Court. That same day at 2 p.m., the Chief Justice caused a bailiff to present him with a notice of hearing for the next day. As we speak, he will have to go to court the next day. The Chief Justice heard the case and dismissed the injunction suit. As we speak, and this was in March this year, as we speak, the Attorney General is even yet to file a response to the injunction writ. So without a response from the Attorney General, the Chief Justice proceeded to hear a matter that was before her court and pronounced judgment. Samson, with the greatest of respect, in another case of Bernard Ahiafo and two others, you were the lawyer in that case. Again, within 24 hours, in fact, the same day you filed your writ, the Chief Justice caused you to be served with a notice of hearing for the next day. And the Attorney General came in that same day. You were compelled to get his response the next day and argue your case out, and she passed judgment.
That was for an interlocutory process, not the case itself. Not the case itself. That was for an interlocutory process. And the Nipapo Samuado one you refer to is also for the interlocutory process, an application, not the substantive suit.
Not the substantive suit.
Hello, Sam George.
The reason why, hello, can you hear me?
Yes, go ahead, quickly.
The reason why we are unable to transmit the bill to the president is not the substantive case. It is the interlocutory injunction. And in this instance, all arguments and pleadings have been completed.
Okay.
So the Chief Justice and the Supreme Court have no reason not to pass a hearing in that interlocutory injunction case and allow the processes continue to the president.
Thank you, Sam George. Thank you for your time. That will be all. We have been trying to raise the GBA PRO, Xavier Kudje. I understand we just got him. So, Xavier Kudje, quickly, what is your response? The facts as we have seen them, and I try to correct Sam George on the other issue, is that the writs themselves, the three that have been filed against the transmission, against the anti-Galamsey bill itself, the writs are not ripe for hearing. He is suggesting that the court or the CJ can fast-track the process in the same way that the court or the CJ fast-tracked the interlocutory processes. What do you say?
I think that the brief I have from the Registrar of the Supreme Court is that there's an application pending by one of the defendants in the Richard Sky case for leave to file his statement of case. So I think that unless and until that application is heard, and that application was filed, I'm told, at the beginning of this month, and it will be heard sometime next week. My only concern is that St. George and Co, Honorable St. George and Co, could have done some search at the registry before proceeding on their process. And the other concern I have is the kind of language that the processors use when they go to the Supreme Court.
So let's stay on the substance. Let's stay on the substance.
Can speed up the process.
Let's stay on the substance. What would have the search that you wanted them to do? What could they have revealed?
It would have revealed to them that at least one of the parties in the case had an application pending, and for that reason, unless and until the application is heard on its merit, the court couldn't have.